Hello, and thank you for joining us. Today, we're going to talk about recent changes to the employer-employee relationship and what employers should do when ICE comes knocking. I'm joined by Catherine Brustowicz, who's a member of the Wagner Law Group's employment law team. She is an experienced and skilled counselor and is often referred to as a business best friend. And my friend Deirdre Nero, who is the founder of Nero Immigration Law, and Deirdre is so well regarded in the immigration space. So, Catherine, let's start with you. You're in the hot seat. Deirdre, stand by.
Well, thank you for that kind introduction, David. I
You
think,
got it. Catherine, can you do, before we get to the substance, a bit about you? How did you come about choosing employment law as a specialty, and what do you find most rewarding about your practice?
it's a great question. I think that you probably know as well as anyone that I didn't exactly choose employment law. Employment law essentially chose me. I was pre-med undergrad, and I had spent about 7 years in the clinical research world, working at a hospital. And so I had figured that if I was going to go into law, it would most likely be specializing in med mal. But I took quite a few med mal classes in law school, and I didn't find the subject matter to be quite as compelling as I had initially anticipated that it would be. Um, so I ended up taking a summer clerkship, and then I started with various internships during law school, trying to seek what my subspecialty might be. And I happened upon a summer internship with the Wagner Law Group. And I ended up, working with you, David, of all of the attorneys at our firm. And you exposed me to employment law and human resource law. And that was it. I was hooked. I realized that employment law just has such a huge impact, not only on businesses and companies, but on employees as well. Almost everybody is either an employer or an employee. So I love that aspect of practicing employment law. And obviously, zealously representing my clients, arguing in court is lots of fun. I do enjoy that. But I think that the most satisfying bit for me is sharing my legal knowledge with my clients. I like to be able to help my clients remain in compliance with the law, which oftentimes is simply teaching them about the law. I am, of course, there for them if they do get into trouble. I'm there to represent them. But I do find the sort of teaching element of employment law to probably be the most gratifying for me. And I don't think it's any secret, but my least favorite part of employment law is just dealing with very voluminous discovery documents and such. So that facet of litigation, I have to say, is my least favorite.
I don't blame you at all. Thank you. So, are there any specific recent changes to the employment law landscape you'd like to discuss during this program?
Yeah, actually. So there have been quite a few changes recently. I think that at this point, the president has signed 157 executive orders in 2025. And so the employment law landscape has certainly been shifting under the current administration. And today I would like to focus specifically on DEI practices, and then I'd like to share some tips for employers to try to stay in compliance with the law. We'll go over some of the new rules and some of the new guidance that has come out from both the EEOC and the DOJ. Let me just advance this next slide here. I just realized that we're behind by a slide. Sorry, I should have gone over this a little bit sooner, but this is our agenda. We've already had our introductions. We're in the midst of the Q&A session here with me. Again, I'm going to be focusing on employment law, specifically some of the DEI related changes. Then we'll turn things over to Deirdre Nero, who's going to be talking about ICE and immigration law. And then we'll wrap up with a thank you, and we'll share our contact information with you so that you have that as well. So sorry, just to get back now to some of the DEI related issues I was talking about. So I'm going to be focusing on specifically the first two bullet points here are the names of the two executive orders that are DEI related. And then the last two bullet points are the two pieces of guidance that have recently come out from the EEOC. Back in February, when David and I had last presented on this with some of our other colleagues, these two January executive orders were standalone. They did not come along with any kind of guidance. And they're very broad, and the executive orders themselves didn't define specifically what an illegal DEI program might be. And so at the time of our last webinar, no one really knew what the full scope of these orders was yet, or really understanding which practices could be consistent with the orders. So we gave our best professional opinion at the time, and we were actually pretty spot on, which is great. But then in mid-March, these two documents came out as guidance. They're technical assistance documents, and they do provide a little bit further clarity that was initially lacking with the executive orders. So the first one there is much more comprehensive, though, what you should know about DEI-related discrimination at work. The second one, that is what to do if you experience discrimination related to DEI at work, is much shorter. It's just it's a short one-page Q&A essentially, but they're both quite helpful, and they are also available on the EEOC's website. If you haven't taken a look at those yet, I would suggest that you do that. And what the guidance does is it explains the application of civil rights laws to employment practices, including DEI programs. And I would say that the very high level take-home message from the guidance is that Title VII's protections apply to all employees. It doesn't matter if they belong to a minority group or to a majority. So put another way, the EEOC's view is that reverse discrimination doesn't exist. There's only discrimination. So you and I, David, had both talked about this a little bit in our last webinar, but it's really, really crucial to remember that our laws, such as Title VII of the Civil Rights Act, they're not in any way rescinded by these executive orders. They're still the law. And I will talk about that a little bit more later on in this program. So thank you, David. Great question.
So does the guidance actually identify prohibited policies or practices? The executive orders were a little unclear on what exactly an illegal DEI practice is.
Yes, unclear, murky, absolutely. But thankfully, yes, the guidance does provide some clarity. And it specifies, for example, that employers cannot apply unlawful preferences in making any employment decisions. So yes, exactly, to any employment decision. So that is within the hiring process, within promotions, within compensation, even with terminating. So that all might lead to disparate treatment. And under Title VII, that means that employers cannot take the employees belonging to any protected class, their race, their sex, their religion, into account when they're making any type of an employment decision. So that pertains not only to the hiring and firing decisions, but as I mentioned, also to promotions, also to demotions or raises, or the benefits that are offered. And it even gets as nitty-gritty as mentoring opportunities. The guidance also explains that employers are prohibited from limiting membership in employee resource groups or to affinity groups to only employees of certain genders, race, or ethnicity. The Q&A document also notes that objecting to any DEI programs, that might actually constitute protected activity. So that could, in theory, give rise to a claim of retaliation if an employee objects to some of the DEI programs and then is retaliated against. And then there are a few other examples that I'll definitely share in a little while, a little bit later in the program.
So let's get proactive, Catherine. Do you have any high-level suggestions for what employers should be doing now so that they can protect themselves?
Yes, absolutely. Great question, David. Thanks for posing that one. First of all, I think that this is a really important time where legal counsel is going to be super helpful. Legal counsel can help you as an employer to review all of your human resources practices. Why, you might ask, would you do that? It's because legal counsel can help you to identify any policies or procedures that you might have that might be perceived as including illegal discrimination or preferences under either state or federal law. So that includes reviewing practices related to hiring, to promoting, to compensating, training, mentoring the workforce. So it's really broad, the amount of policies that really do need to be reviewed. And remember that companies are still legally required to honor their obligations under federal law. So that includes Title VII, which I've been discussing. It includes the ADA. It includes DIA. And with the variety of executive orders that are coming out, it is sometimes easy to forget. But our legal precedent, our laws, our existing case law, those are all still the law. And those aren't impacted by or rescinded by these executive orders. Thank you, David.
You bet. So you discussed increased scrutiny over legal or illegal DEI programs. How do you suggest private sector employers handle that increased scrutiny?
Yeah, so that's another very timely question, and I'm glad that you posed it. We talked a little bit already about reviewing our policies, getting legal counsel involved. I think that a really good and relatively straightforward way for private sector employers to deal with this increased scrutiny is the way that they frame the idea of DEI. So DEI is not about exclusion. It should be about inclusion, as the first bullet point on the slide here says. So if a DEI initiative of yours in any way excludes people from a benefit based on their race or their sex, for example, maybe only ethnic minorities or only women are eligible for certain workplace benefits. That would be problematic. That would most likely be deemed to be an illegal DEI practice. Those are certainly at heightened risk right now. So put in another way, programs cannot confer advantages based on membership in certain groups. I think that that's a really good way for employers to view DEI in general. That will help you when you're reviewing your policies to make sure that you're staying on track. If an initiative is instead about ensuring that all employees are aware of opportunities and benefits, then that's generally permissible. So keep in the back of your minds, DEI is about inclusion, not about exclusion. That is a good tip to try to help you, stay in the legal lane, if you will. Making sure that all employees are treated equally and documenting any decisions that are made. Do so and make sure that they're done based on merit. They should be color and race and sex blind. So we're essentially trying to be neutral in our policies here. We're trying to treat everybody fairly in an inclusive fashion, not bring in their belonging to any particular protected class. Also be on the lookout for any types of preferential hiring or promoting decisions that might be based on general demographics. You're not going to want to limit access to training or mentoring. Again, we're about inclusion here, not about exclusion. And when you're hiring, please don't set quotas based on gender or based on race. The EEOC has made it clear that that is very problematic. So when you're reviewing your policies, if you see anything with respect to quotas, you should really edit that program. And then also the EEOC has noted that balancing your workforce based on protected characteristics, so race or sex, or other protected traits, those would violate Title VII. And so those would be deemed to be unlawful DEI practices. One thing that I will note, just with respect to the first bullet point again here with inclusion, it might not be enough to open preferential programs, like, for example, maybe Black employees, resources groups, or resource groups for female employees only. Opening those programs up to everyone, that might not cut it. It might not pass muster, if you will, because the focus is still going to be on the underlying intent of that program. And it's pretty clear that if you have a Black employee resource group, the intent there was to give preferential treatment to specifically Black employees. Same goes for the other example with the women's group. So just be mindful that changing the name of a program might not be enough just based on the current increased scrutiny that these programs are currently under. And then again, I know I mentioned it, but it is worth repeating. If you're ever in doubt, it really would be quite prudent for you to reach out to legal counsel, even if you just have a question. It's better to be safe than sorry while things are under such scrutiny. And then one last tip here. When you're reviewing your policies and your practices, please don't forget to also review your company's website. The DOJ or the state attorney general, they may be monitoring websites for information about illegal practices. So it's not just what you're doing in practice, it's also what you are projecting to the world on your website. So please go ahead and take a look at your website to make sure that that's up to date too.
Catherine, some great points there, but if I can add two things.
Please.
One is, with respect to your policy and your website, a disgruntled current or former employee could also become a whistleblower and report to the state or to the Federal Department of Justice that there are things on the website that are inappropriate. So that's another reason to want to make sure your policy is up to snuff. And something I can't say often enough is document.
Yes.
You mentioned the document earlier in that answer, but it's so very important. It's not just document, but talk to your attorneys about how you should go about documenting, steps that you take. So Catherine, one more question for you.
Sure.
This is very broad-based. Is there anything else that you'd like to touch on regarding the current state of DEI?
That is broad. Thank you, David. Yeah, I think that my last point on this is that today, a lot of companies they're a little bit scared. They're running scared based on these executive orders. And several large companies have publicly announced already that they're going to be cutting back on their DEI initiatives. And I think that that's a little bit dangerous. But if I had to surmise, it's likely largely based out of fear. Or perhaps because these companies rely on federal funding and they're concerned about the consequences. But the law does not mandate that DEI programs be curtailed in their entirety. That's not what the law says. That's not what these executive orders are saying. And this is specifically for private sector employers. I think, in fact, it's more important, rather than cutting your DEI programs and initiatives, to simply very carefully tailor them. Tailor your programs, tailor your initiatives so that you remain in compliance and so that they remain in effect. I am concerned that the negative effect of eliminating DEI initiatives is going to, really negatively impact the workforce. And ultimately, probably through the trickle-down effect, it'll end up impacting our economy. You want to keep your workforce happy and engaged, and that's why we're focusing DEI on inclusivity, not about exclusion and excluding people. So even though people are scared right now, they don't want to be targets, rather than completely cutting your DEI programs and initiatives. Just change them. Make sure that they are in compliance specifically with Title VII. That's the biggest area where employers can inadvertently get into a little bit of trouble. So please don't eliminate your programs. Just audit them. Audit your policies. Review them with a lawyer, or even with a consultant. And with that, I think that you will be able to keep up the very good non-discriminatory work, and you'll be able to make your workforce feel included without feeling like your company is in danger of being targeted. So yeah, that's the last bullet point on the slide here. Don't panic. Things do seem scary, but there is more clarity now due to this guidance that has recently come out, and this is a navigable path. So don't panic.
Thank you so much, Catherine. And Deirdre, as you're getting your slide deck up, I do have one thought. DEI is one tool to have a great workforce, a productive workforce, an inclusive workforce where people are treated with respect and appropriately. It's a tool. It's not the only way to go about doing it. So that's something to keep in mind. And we're fortunate to have Deirdre join the Wagner Law Group for this webinar. I've known her for some time through a professional organization called Provisors. She is a thought leader and she's a great speaker. So Deirdre, before you get into substance, same question I asked Catherine. How did you choose to be an immigration attorney, and what has been most rewarding to you about that? Tell us a bit about you.
Oh my gosh. So while I have the slide, first of all, hello, and thank you for letting me join you for this. It's such a pleasure to be invited to collaborate with your amazing law firm and the two of you specifically. I thought I'd have up on the screen a little bit about me so that the people watching can connect with me on LinkedIn and stay in touch. But, I really just always, well, first of all, as a child, my kindergarten teacher used to tell my parents that I like to argue. And so she thought I was going to be a lawyer. And my parents just thought that was the most hilarious thing they had ever heard and proceeded to repeat that story to me during my formative years. And so I kind of feel like looking back, could have been anything, but kind of was being told at a young age what I was going to do. And I just, had that ingrained in my brain forever and ever. I'm thankful for that. At the end of the day, I mean, I can't really imagine anything else that I could be doing right now. So I think I found the right calling for my career, and specifically immigration law. It's so funny. I always, in law school, I was like, oh, every class, I don't like this. Like, I can't imagine doing this for the rest of my life. And then I finally stumbled upon the immigration law class, and I just really loved it. And it was the first time I felt like compelled to actually do the homework and read the chapters being assigned and raise my hand and answer. And all the other classes I was kind of shriveling down, hoping not to be called on, and not doing the assignments nearly as much as I should have been doing. So I think that was my first kind of hint. And then I was lucky enough to have one of my first jobs, and also the firm that I started my career at, in the international department of a Florida firm called Becker. And at the time, they had an immigration practice, and I started being able to get some hands-on work that kind of backed up what I had learned in the class. And that was it. I was hooked after that. So I've actually never done any other kind of law. I've been practicing for 22 years. And I've only ever done immigration law. So luckily, people still want to come to the United States and stay here and work here and become residents and citizens. And hopefully that doesn't change anytime in the future, because that's the only thing I know how to do. So there you go.
Well, that's great. And by the way, just so you know, I've heard her argue. She is incredibly persuasive.
I like to argue. Can't help it.
Okay, well, I'm going to ask you a more specific substantive question now. And we've heard all this stuff about ICE. And let's say ICE shows up at a business for an I-9 audit. What is the first thing an employer should do or not do?
So first off, I'm going to kind of jump to part of your second question because I already know what it's going to be, but not to give away our secret, but I know what your second question is. And I just realized that, this first slide kind of hints at the second question, but there is a difference between like the type of ICE visit that you might get at your company as an employer or at your business. One is definitely much scarier, I would say, than the other, but they can both be painful. So we're going to discuss both today, but let's start with just, the two, which is either arriving to give you a notice of inspection that you're going to be audited for your I-9s. And the other one is kind of like an unannounced visit where they're coming in to do a work site enforcement action, and you might hear them referred to as raids. So that's kind of like the two differences. But to go back to your actual first question, an I-9, is a form that every employer needs to give to their employees to verify who they are and that they're authorized to work in the United States of America. Those are the two basically points that the I-9 is driving at. A lot of, especially I see smaller businesses that don't maybe have like a full HR department or someone who's like fully in charge of their HR, they really get into a lot of trouble with this stuff because they just think, I don't need to worry about that. All my employees are legal or, whatever, or I'm just not going to be bothered with that. This is not a form that I have to actually turn in to the government. You don't actually like file that form proactively. You only have to show it to the government if they audit you. And so unfortunately, that leads to a lot of complacency where employers are just can't be bothered, or maybe they'll do it, but they're certainly not doing it correctly. So, it's very important that you kind of understand what your obligations are for I-9, and then that you learn how to properly do the I-9s in the first place, but then also how to properly maintain them, store them, all of that. So if you were to get visited by ICE for an I-9 audit specifically, you're only going to have 3 days to turn over the information that they ask for. And so that's not a lot of time, especially considering that a lot of times, most times, all the time probably is a safer way to say it. But at least 9 times out of 10, they're not only going to be asking for I-9s of the people who are actually working for you in the moment, but I-9s for people who were working for you during the period that you're supposed to be keeping the forms. And so it could be a lot of people, especially if you're in a type of industry that has a lot of turnover, even if maybe at the current moment you don't have a lot of employees. So it can be a lot to deal with. And so that is why my main point of how to protect yourself if you do get a visit for an I-9 audit would be to do an internal audit. Right. An internal audit is something that you as the employer are going to do in advance of ever getting visited by the government and being asked to produce your I-9 forms, where you're internally looking and auditing either all of your I-9s or a selection of them to see where you have problems, and then also correcting the problems. And so this is going to help you identify any problems before ICE comes to visit. You can do this on your own if you know what you're doing, or like with an HR consultant or something like that. But I do recommend that you do it with an immigration attorney that is, qualified to do this type of work. And that's also going to add some, confidentiality to the process and all of that. But doing this regularly is going to keep you kind of with your best position forward in case you do get visited. And also if you do get audited, one of the, which I'll get to in a second, ways that you can mitigate a fine is to show that you've been doing regular self audits. And so you have a good faith to try and comply, even if you still have mistakes. Right. So these are some of your best practices for an internal audit. A lot of my slides are like super meaty, and I'm not going to get into all the detail, but I made them detailed so that you can go back and use this almost like a manual reference guide. So I'd be happy to share this with anyone watching so that you can go back and look at it specifically. But you do want to just make sure that everyone has timely completed the I-9s. Section 1 is supposed to be filled out by the employee on their first day of work for pay. Section 2 is supposed to be completed by the employer by the end of the 3rd day of work for pay. The way that they count is a business day for that company. So the reason I word it that way is because, for example, my law firm is only open Monday through Friday. I think my employees would revolt if I, said that we were open 7 days a week. But a hospital is open, 24/7, 365. So they're going to be counting the days differently. So it's counted not just Monday through Friday. It's counted when your company is open for business. And so that's going to be different for like restaurants and retail and, hospital than for your traditional offices or things like that. You're going to be checking the employee's documentation to make sure that it's valid. You're going to be retaining the forms correctly, hopefully. This is something you want to be checking in on, whether it's being retained for your current employees for at least while they're still working for you. So if the person's still working for you, you need to keep their I-9. If the person is terminated, then you need to keep it for at least 3 years after they've been terminated. Okay, so that's something else that you're going to have to keep track of. And then also you want to get on a purge schedule, because the thing that you don't want to do is keep ones that you don't have to keep under the law, because then you might end up turning over things and getting fined for things that maybe you weren't legally required to even be retaining in the first place. And if you don't know all those little rules and you don't have someone like myself kind of walking you through this, then you might not even realize that, and you might end up paying fines for things that you didn't even need to have in the first place. And the government is not your advocate, right? So they are not going to be like, oh, oops, we made a mistake. We shouldn't have been, fining you for these people. Like if you don't proactively point out, people that, or fines that shouldn't be there in the first place, then, you're out of luck most of the time. If you're using E-Verify, you need to make sure that you're using E-Verify correctly. Make sure if you're in a state where it is mandatory for either all employers or certain subsets of employers that you are using it and using it correctly. If you're going to correct errors, make sure that you're doing it the right way. You never want to white out or erase. You always want to make like a single strike through and then an initials and date. And then if you want an explanation of the error and the correction is always, I opine, a good idea. And then make sure that your people are trained up to know, like the people that are responsible for doing this in your business ought to be very well trained on all the nuances. This is like a super high level gloss over of an internal audit, but just to give you an idea. Here you see how complicated the process can be. I did not create this chaotic mess that you see on your screen. Like this is like literally you look at this and your eyes cross because it's so confusing, right?
Hold
This
on,
is actually
Deirdre, just
straight
one
off the
second.
government's page.
For the record, I did not create it also.
Yeah, this is like right off the government's page, as you see so you can see how chaotic this can be. And this is just like what actually happens. And the top is notice of inspection, where they arrive at your business and serve you with a notice that they're going to inspect your I-9 forms. Just quickly before we move on to kind of the raids topic, just showing you, these are ways you can either have your fines decreased or increased, so aggravated or mitigated. So you see good faith is one of them, the size of the business, seriousness, whether you have actual unauthorized workers or if it's just, paperwork violations, histories of violations. So if you've been in trouble for this stuff in the past, you're going to get your fines probably aggravated, etc. And then to give you an idea of what the fines actually look like, here you go. Just for substantive and uncorrected technical violations, so like failing to properly complete or retain the form, $288 per violation up to $2861 per violation. You can imagine how quickly that can add up. If you actually have unauthorized workers, it can go even crazier, right? You're looking at 716 to 5, almost 6,000 for unauthorized worker on first offense, and then it just gets worse and worse if you're a subsequent or repeat offender. And then last but not least, if you're engaging in some kind of document fraud or you're complacent to some kind of document fraud, fake socials and fake driver's licenses are rampant, especially in hospitality and restaurant industry. You can get fines ranging anywhere from 590 to almost 5,000 for first offense, and then it goes up for subsequent offenses, can range all the way up to almost $12,000 per. So you can imagine that as you are having more and more I-9s and more employees, and that would just be like for one form that had errors on it, or one employee that was unauthorized, or you had document abuse. So that multiplies exponentially, and I don't want to make you scared unnecessarily, but it could put you out of business. Like the fines can be that intense. So making sure that you are in a good position if this does happen to you, so that the fines are as little as possible, is going to be your best defense here. Thanks, David.
Okay, thank you so much. And that goes back to that documenting again. If you do make your own effort to audit and comply, just have a paper trail of good documentation on it. And before we get to the second question, as a reminder, if you're having any difficulty with connectivity, reach out to us at webinars with an S at the end at wagnerlawgroup.com. So Deirdre, you kind of hinted at the whole bit about raids before. What's the difference between an audit and a raid, and how should an employer's response differ to an audit or a raid?
So when the ICE officers show up for an audit, they're going to serve a notice of inspection on the employer, and then you're basically going to have 3 days to turn over the documents that they're asking for in the notice of inspection, and then, pretty much they're going to leave at that point. That is not what happens with a raid, right? So let's get into the raid topic a little bit. They're going to show up unannounced. The officers are going to be, in multiples. And basically it can be a really scary event. So you want to make sure that you have a plan in place. I would say the first thing that you want to do is call your lawyer immediately, and train whoever is your first line person. So when someone walks into your business, whoever is the first person that they would see ought to be trained to at least say something like, our company policy is to call our lawyer, and I'm going to do that right now, and call the lawyer. Okay. And so if this person is completely caught off guard, you might be in a position where your legal counsel is not being called at the time that they ought to be. So I think that some of my slides coming up are going to get into the next question. So I'll let you go ahead and ask me more things, David.
Well, thank you so much. When ICE presents a warrant at a workplace, does the employer have to let them in? How do we know if it's a real warrant and what kind it is?
Okay, this I think is really important. And in fact, over the weekend, I was talking, texting, really, not talking, but to a colleague of mine, a lawyer from another firm that I know through networking. And he said to me, hey, I had a client of mine that got raided over the weekend or last week, and they arrested 150 of his 190 employees and took them away. Then he said, then I had another employer that also got visited, and they knew enough that it wasn't the proper warrant, and they didn't let them in, and no one got arrested. So you can see just there, knowing little things about like what to do if you do get visited, and like what kind of warrant you should be looking for, can make a huge difference in basically losing, 3/4 of your workforce in a second to being arrested. So, that's an extreme, I think, example, but, it's literally something that just happened. So basically, the ICE officers are going to be free to enter any public areas of your workplace, but they have to have a valid warrant or your consent, a valid warrant or your consent, right? So if you consent, they don't need to have a warrant, like, period, right? So like they can come in and go into the private areas if you let them, right? But if you don't let them, unless they have a valid warrant, then they can only enter the public areas, not the private spaces. Okay, so the difference between the two types of warrants is going to be, one is a judicial warrant, and that is what the proper warrant for this type of behavior would be. And the other one is called an administrative warrant. A lot of times they are coming with administrative warrants. And that warrant is not something that gives authority for ICE to enter private spaces or to seize evidence. And the thing is that a lot of employers don't know the difference, right? They haven't listened to one of my webinars where I go on ad nauseum about this. And so they don't know. They just see the word warrant and they think that it means that they have to let this ICE officer do whatever they want. So, that's not the case. An administrative warrant is going to be something that's signed by like an immigration official, whereas a judicial warrant is going to be signed by a federal judge. And so that is going to be your main difference. The judicial warrant is going to allow access to private spaces, even if you say that you object, they can still enter if they have the judicial warrant, right? So you should be able to tell just by looking at the warrant what the differences are. Definitely, if you see the seal or label of an agency like the Department of Homeland Security, the signature is an immigration officer or an immigration judge, that's a dead giveaway that it's an administrative warrant. The judicial warrant is going to have the authority of a federal court stated on there, and going to be signed by a federal judge or a magistrate. And it ought to state with specificity the premises, what's to be searched, and the time period. And so that information also needs to be stated on there with specificity. Okay, so you definitely want to make sure that you are making the person who is the front line person aware of these differences and what to do, right? If they come in and this person is scared out of their mind, you want to make sure that they understand, who to call in your company, who they ought to be contacting in terms of like the attorney, potentially even how to differentiate between the types of warrants. I mean, these are all things that you want the frontline person to know and understand. At the very least, who to call, both in the company and in terms of your legal counsel. That ought to be like the very least of what you tell them. Also, just a word: if you don't consent to the search is still going to proceed, but at least you're making your challenges known. And I think that that's really important to understand, is that it's still going to happen even if you object, but you want to get like your objection on the record. You definitely want to have assigned people following the agents around and recording whatever's happening, either recording it on a video or writing down with extreme specificity everything that's happening. That's really very important. Okay, I think that you can ask me the next question, David. I got lots of stuff to say about this stuff, but we're gonna, in the interest of time, move on.
I mean, between the two of you, this is also cutting edge. So I can imagine a workplace where the employees start to panic and start to leave during an ICE raid. What are the legal risks for the employer in terms of obstruction or retaliation claims?
So you definitely, let me get to that slide. Okay, so you definitely need to think about a couple things, right? You want to think about your employees because you care about them and you want to protect them, but you also, as the employer, need to protect yourself as the employer. hiding employees, helping them escape off the premises before they can be seen, providing false or misleading information. All of this can be considered to be a federal offense. I would not do any of that. Okay, you need to be very careful with not, although you may be tempted, right? Because these are your people and you feel like you want to protect them. And a lot of times our employees, you know, feel almost like family to us, but you need to really resist the need, the desire to do that. You also, though, because you don't want yourself to get into even more trouble, right, than you would be otherwise already. But at the same time, like, the other side of that coin is these are your people. You need to make sure that they're, you know, taken care of in the best way that you can in a situation like this. So don't forget the health and welfare of your employees. Something like this can actually take a really long time. Like, the officers could be there for hours potentially. So if you have employees that you know require medical attention, that have kids waiting on them to be picked up from school, that, you know, have other like really pressing concerns, make sure that you're communicating that to the officer and you're trying to take care of your employees to the best of your abilities. You ought to ask the officers if your employees are free to leave. If they're not free to leave, then that means that they have the right to an attorney. Additionally, your employees have the right to remain silent, and that's something that you want to make sure that they understand. You should not instruct your employees to not speak to ICE or to refuse to speak to ICE. You can't directly instruct them. If ICE comes, don't say anything, keep your mouth shut. That is not what you want to do. You want to tell them, if this is to happen, you have the right to remain silent. You don't need to answer any questions. You don't need to answer questions about your immigration status, where you were born, how you entered into the United States, and when. You can stay quiet and exercise your right to remain silent and ask if you can speak to an attorney. If you're not free to leave, you have the right to speak to an attorney. Another trick that we've heard about happening is asking the employees to talk without talking. So what does that mean? It means everyone go stand in that corner if you're a US citizen, and go stand in that corner if you're a foreign national. And they're basically getting the people who are not speaking out of their mouths speak by physically moving into a certain part of the room or doing something like that. What you want to impress upon your employees and make sure that they understand is that they don't have to do that. The right to remain silent includes the right to not do that. Okay. So what they can do instead, if ICE tries to pull that trick, is go stand in a third area that is like an undesignated area and not go into one of the groups that they're asking people to move into. Okay, so that's really important, and just knowing that they don't have to show their documents if they don't want to. You know, maybe they want to. Maybe they're like, I'm a citizen, right? I want to show my document. Like, you really have to give them the agency and the right to make their own decision in that regard, and just make sure that they are aware of their rights, but you know, you're not making that decision for them. And the same thing kind of goes on the I-9, right? Like, when you're giving the employee the list of acceptable documents that they can present to prove their identity and their work authorization, you as an employer are strictly prohibited from saying, come back tomorrow and bring your passport, come back tomorrow and bring your green card, bring me this document or that document. That is actually an offense under the laws for compliance with I-9. And you can get in trouble for that. So what you need to do is give them the list of acceptable documents and give them the freedom to choose which documents on that list they're going to bring back to you to show their identity and their work authorization. So that kind of is a corollary here in a lot of ways. You don't want to assist anyone in leaving the premises. I think that that's really important. Thanks, David.
Okay, so Deirdre, I've heard you talk a few times, and one thing I really admire is when you get proactive. So what are the proactive steps that a business can take now before ICE ever shows up so that they are better prepared and they can minimize liability?
So I think attending this webinar is a great first step, because at least you're understanding that there are two types of warrants, and maybe you need to learn the difference between the two so that, things like that. So education for sure is your first step. I would say really important to create a crisis management response team, so that exactly kind of like who's gonna be in charge of something like this happens and who's gonna do what, right? You want to review contracts that you might have obligations that, like, think about this employer I mentioned. If they lost 150 out of 190 of their workers, like, they're probably not going to be able to meet deadlines on contracts that they're obligated to. So you need to review that and find out what's going to happen if you have delays or disruptions in obligations and work that you need to be delivering. Employers need to make sure that they have all the emergency contacts up to date for employees. Super important. We've heard crazy stories about people just basically disappearing, and family members and employers being unable to locate the person for days and days at a time. So make sure you have all your emergency contacts of everyone up to date. That's super important. You want to create a plan about who's going to interact with the ICE agents in your company, who are responsible, trusted members of your team that can be kind of in charge if something like this happens. Because remember, you're going to need probably more than one person, because you're going to want to be recording either on video or in writing everything that's happening with great specificity. So you're probably going to need more than one responsible person to be doing things like that. Have your hot numbers ready, attorneys, union reps, anyone that you need to call right away. You want to have that stuff ready and updated, and make sure that your frontline person has access to it and knows how and when to use it. And then, of course, auditing your I-9 and your E-Verify practices is going to be super important, because guess what? Not only when you're audited are you going to be required to turn over these documents, but when you're I-9 audited, but when you're facing a worksite enforcement action like a raid, they're also going to want all of that information. And so you're going to be opened up to all of that in this process as well. I definitely think that your crisis management response team ought to consider these things. Who's going to contact the legal team? How to, have we set up files for terminated employees' I-9s? Who's the main point of contact to coordinate with ICE? Who's going to address notifying family members of employees, especially if they've become detained? Is your outside counsel going to be able to get on the phone, and are they going to have indirect or direct access to ICE? There's a form you can have on the ready called a G28 that shows who your lawyer is and that you're represented, that you can hand over, so the ICE officer immediately knows that you're represented by counsel. And then last but not least, what kind of PR messaging crisis is this going to potentially create for your company, both internally and outward facing to the public? Because that's also something that we need to consider, is what is this going to do to the reputation of your company?
Deirdre, thank you so very much. And Catherine and Deirdre, you both touched on some critical hot topics, and I appreciate it. So Deirdre, your contact information, if you can
Here's
just
my contact information. And if you would like, after a couple seconds, I can stop sharing so that Catherine, you can put your information up and David's information. Good?
Sure.
Sounds good.
There you go.
What I can
I
say
skipped over
is,
a couple things, David, that were like resources and links people can look at and things like that. So that would be available to anyone watching this. I'd be happy to share the slides.
that's
Look,
great.
you put my information too. Thank you. That was so nice.
You're welcome. Of course.
Very nice.
Folks, just keep in mind, if you say, well, I'm going to wait to see if something happens, then reach out to Deirdre, it's too late. She's the kind of person you've got to talk to now to make sure that your immigration practice is up to snuff, not after they come knocking at the door. And
That's
same
a great
thing
point,
with,
David.
you got it. Then same thing on the employment side. Catherine is incredibly proactive. She's been working with me now for almost 10 years in one form or another, and she's got a lot to share. So feel free to reach out to any of us. One of the things is we love talking shop. We're here for you. Thank you so much, Deirdre, Catherine.
That's true.
And thank you so much, and Shalom. Thank you for helping us out as well. You all have a great day. Thanks again.
Thank
You
you.
too.
Thank you so much.